Yeah, if you could, that'd be great. Right then, I'll do a sound check first of all. If anyone can't hear me, then could you raise your hand on the old raise your hand icon at the top there? Good. Well, as you can see, we're absolutely inundated with attendees this afternoon. Um, I think there's obviously a problem with the server somewhere, and that everyone else is stuck in cyberspace. But what I'm going to do is I'm going to make a start because these are recorded anyway, and I'll start by thanking those of you who are here for attending. This is our commercial law with lunch with myself, Adam Gould, and Stuart Roberts. The aim of these seminars is that they are short and relatively informal, and of course give you an opportunity to get some CPD points whilst you're eating your lunch. Ordinarily, I might add that they would be entertaining, but having seen that the roster is agency and part 36, I shan't make any promises in that regard. Audience participation is not compulsory, but it is appreciated. So if anyone does have any questions, feel free to either put your hand up, put them in the chat box, or save them for the end when Stuart and I will run a Q&A session. So I think I'll let Brian in the lobby. So picking up on agency then, in the last 12 months, I have dealt with at least 3 cases which have broadly followed this pattern. And it's where person A promises to transfer shares in a private company to person B. Usually, but not always, that promise is to entice B into joining the business, working as part of the business. A later reneges on that promise, and then B finds themselves in a position where they want to enforce that promise to secure those shares. And usually that looks something like a contract claim, or it might be a proprietary estoppel claim. The agency point is this, and it transpires that A does not actually own the shares, so A being the person that's promised the shares, doesn't own them. And the common feature is that they're held by a parent company, or it might be that they're held by someone different entirely. And I find that the misconceptions on this are twofold. The first misconception is that A must have been promising the shares on behalf of P, so that's the parent company, the third party in all of this. And the second misconception, which follows on from the presumption in misconception 1, is that it is sufficient to direct the claim solely to P, i.e. the parent company, and plead that A was at all material times P's servant or agent, which of course you'll all be familiar with as a general plea that we make in almost 99% of commercial disputes. These are not artificial misconceptions. These are points that I've seen pleaded, and unfortunately I've seen them pleaded by very experienced barristers who have gone before me on a case, and unsurprisingly, after there's been a strikeout or there's been an amendment, they've been sacked. So dealing with the misconceptions in turn, I'll deal with misconception 1, which, just to remind you, is that A, that's the person promising the shares, must have been promising the shares on behalf of P. So that's the person that actually holds the shares. And why is this problematic? Principally, my view is because it releases A from the claim without giving any thought as to how they may personally have incurred a liability to B. This is a practical problem for reasons that I'll come on to, but it's also a presentational problem. And it's a presentational problem because the person guilty of making the representation and reneging on the promise, i.e. the baddie in all of this, doesn't feature as part of the litigation. And what you end up with is 2 innocent parties in court fighting out what should happen to these shares. And my view optically is that it's much better to have either a claim against the fraudster or the reneging party, or at least have them there in some capacity to be able to point the finger at them. Returning to the practical problem, releasing A from the claim creates an extra hurdle between B, that's the person to whom the promise has been made, and a successful outcome, namely the requirement to plead and prove agency against P. What is the solution to all of that? It's hard to prescribe a one-size-fits-all approach, other than to say that detailed instructions should be obtained in relation to, first of all, the promise. So what were the main events or prevailing state of affairs leading up to the promise? What exactly was said, what was done, and was any of it reflected in writing? Then we turn to A's interest in P, in the parent company. Does A wholly own that company? Do they partly own it? What is the extent of their interest in P? And then finally, A's interest in the promised shares, i.e., are they beneficially entitled to these shares? Or do they have no entitlement whatsoever? Having done so, it may become apparent, as it did in one of my cases that I ran earlier this year, that A could cause P, i.e. the parent company, to transfer the shares to B, or demand the shares from P with a view to thereafter transferring them to B. So having taken full instructions, we come to the point where we realise that actually none of this really needs to involve P at all, because construing the promise or construing the agreement takes us to a position where this can just be dealt with between A and B. So in short, the promise properly construed, or an implied term if it's a contract, can be to the effect that A would procure the transfer of the shares to B, rather than this necessarily being a point of agency. The next point is misconception 2, and this is the issue of, is it sufficient to direct the claim solely to P, the parent company, and plead that A was at all material times P's servant or agent? Now, as I alluded to earlier, a plea of agency is not always contentious, and in fact, in the vast majority of cases, we can and do get away with simply saying something was said or done by an agent or servant of a party. However, the last thing that anyone wants is, first of all, to receive a defence denying agency, which in turn necessitates amendments to the particulars of claim. And given agency in the context of this talk will form an important element of the claim, it would be a risky tactic to simply say, well, we can just deal with this in a reply. Or worse still, to get to trial and be challenged on your formulation of agency because it's not been transparently pleaded. For example, if there is a generic plea, but actually B, that's the person relying on the promise, actually relies upon, I don't know, a course of conduct by the parent company that the clerk say with authority, then that's going to need to be pleaded. If you try and develop that in submission without it being pleaded, the other side and the judge are going to cut you off pretty quickly. So if agency is likely to prove contentious, or at least there is a risk of contention, it is prudent to properly particularise the basis upon which it's said by B that A was P's agent. Turning then to the law on agency, because I think it necessarily follows that in order to be able to articulate a plea of agency, we need to know what flavour of agency we're going for. And there is a very helpful summary of the law on agency in a relatively recent case, described by an opponent last week as a weighty authority. And it certainly is that. It's the Law Debenture Trust Corporation against Ukraine. And at paragraph 38 onwards, it deals with, in a reasonable amount of detail, but not something that can't be read and understood in 5-10 minutes, the general principles of agency. And I'll start with that. And I'll start with actual authority. Well, I'll start with the dividing line, which is that the authority of an agent might be actual or apparent, or a combination thereof. An actual authority describes a legal relationship between the principal and agent. So in the context of our discussion, we're talking about A and P, created by a consensual agreement to which they alone are parties, and pursuant to which the principal grants the agent the right to enter into legal relations with third parties on behalf of them. Or indeed, it doesn't necessarily have to be entering into legal relations. It can be that an agent with authority to act in a particular way can bind their principal to representations that they make. So from a pleading perspective then, if we're relying on actual authority, then it's best practice, I think, to identify the agreement that gives rise to the agency relationship, or if it's predicated on some implied authority, the facts and matters that give rise to that relationship. And of course, if we don't have that immediately at our fingertips, then we'll need to think about how we can leverage the pre-action protocol, pre-action disclosure, in order to try and arrive at something that's going to allow us to plead that relatively robustly. The next point, and this I think really is where the vast majority of cases find themselves, is apparent or ostensible authority, which describes the relationship between the principal and the contractor in this case being B, i.e. the person with whom we are contracting with, not to be mistaken with a contractor that doing some building work. And it's the relationship between the principal and the contractor which arises from a representation made by the principal to the contractor. So rather than this being a relationship between principal and agent, it's a relationship between principal and contractor, which the agent actually sits outside of. If the representation is relied upon by entering into a contract with the agent, an estoppel is created which prevents the principal from asserting that he is not bound by the obligations which the contract imposes upon him. For the estoppel to operate, the representation must be one upon which the contractor could and did reasonably rely upon. So we can already see our statement of case taking form in the sense that we have to identify representation and then we have to identify reasonable reliance. And in that respect, it's not really any different to a plea of proprietary estoppel, apart from the last element are slightly different. And of course, if there's anything to put the contractor on inquiry as to the extent of the agent's authority, then that it may well be the case that they can't avail themselves of a plea of apparent or ostensible authority. In terms of the representation that creates ostensible authority, that can take any number of forms, and most commonly we see representations by conduct, which is permitting the agent to act in some way in the conduct of the principal's business or other persons, and thereby representing that the agent has the authority which an agent so acting in the conduct of his principal's business usually has. So we see there that actually the relevant conduct doesn't even need to come from the principal, so long as the principal can be fixed with it in some way and held responsible for it. As I said before, those two aspects of agency can and usually are pleaded in the alternative or in combination, albeit I do tend to find in practice that doesn't tend to be dispute in relation to actual authority because it's there and it's likely recorded in writing, or it's a byproduct of a relationship between two individuals, for example, a director of a company and the authority that they enjoy over the company. The final point on the law to note is the expression usual authority, which doesn't, as I understand it, create any sort of freestanding form of authority, but it generally refers to the authority of a person, the agent, to enter into transactions of a type that are ordinarily undertaken by a person appointed to a particular position. So in that regard, it's an extension of actual authority by the principles of ostensible authority. And the example that's given in the case is a person properly appointed by the board of a company as managing director is invested with applied and ostensible authority to do all things falling within the usual scope of that office, but the board may limit the managing director's authority, and they may say that he is not to order goods costing more than a certain sum without their sanction. That is his actual authority, but of course his ostensible, or as they describe it, his usual authority, may well be capable of binding third parties to transactions that exceed his actual authority, because the company, by appointing him as a director, permit him to carry on in such a way that he carries that authority. So those are the flavours of agency, and those, I suppose, are the points that I would recommend be given consideration and be properly pleaded when there is an instance in which it may well prove to be the case that agency is contentious. By exploring those points at the outset, a very robust position can be pleaded. And more so, it ensures that the disclosure exercise captures the specific plea of agency, which may otherwise be omitted from the disclosure exercise. And finally, then, by way of illustration, I actually dealt with a case the other week through to trial that had been pleaded by Brian Patterson-Whitaker, who's joined us today. I didn't tip him off and say I'd be singing his praises, but he's obviously, his ears have been burning. And Brian had prepared a case, a defence, in fact, defence and counterclaim, and had quite properly and quite helpfully provided a very detailed plea of agency in relation to a site foreman who appeared on and made representations to a neighbouring landowner. So he was on an adjacent parcel of land, and he was making representations to our client. And had agency not been robustly pleaded, there wouldn't have been opportunity to obtain disclosure on that point, run the detailed arguments that had to be run. And whilst this didn't arise, it's relevant in principle. If agency hasn't been completely pleaded, then you wouldn't be in a position to invite adverse inferences from either silence or missing documents which would be relevant to that pleaded issue. It simply doesn't arise as a consideration. So I think in fairly record time, that takes me through my talk on misconceptions in agency. What I'm going to do is I'm going to hand over to Stuart. As I said at the outset, if anyone's got any questions, then by all means, put them in the chat or hang around at the end and we will deal with them then. So without any further ado, thank you for listening, and I'll pass over to Stuart to talk to you about part 36.
Good afternoon. Yes, thanks for coming, those who have attended. I'm going to give a brief canter through 5 fairly recent cases on Part 36. As we all know, Part 36 is hugely important, enables the defendant to change the goalposts about who's won and who's to pay costs, and of course it offers claimants the potential to unlock an array of benefits if they're successful and beat their own offers. So, as I say, there are 5 cases. In summary, it remains the case, I think, that you should always think about making Part 36 offers. I'm often surprised in any case that comes over my desk and it's approaching trial that there haven't been Part 36 offers made. Unless you're going to do something rash, there's very little downside in making a Part 36 offer. And of course, the provisions of Part 36 are very detailed. It comprises its own self-contained code, and it's important to make sure that you keep within the rules as set out in the case law. So the first case I'm talking about is called Henderson and Jones and Price, a case from 2020, but it was only reported, I think, last year. It was a claim about a director's loan. the claimant had made a claimant's Part 36 offer of £40,000. That was made on the 23rd of September of 2020. Trial started on the 14th of October 2020. Claimant succeeded at trial and won just under £95,000 in damages plus interest. And they sought to rely upon their Part 36 offer, which clearly they had beaten by a very substantial amount. Rather begs the question, why on earth didn't the defendant accept the 40 grand offer he could have done? But anyway, the difficulty was that the offer had been sent by email at 7 p.m. on the day in question. It wasn't deemed served until the following day, and that was not 21 days before the trial. So there was a dispute about this. CPR 3617 subparagraph 7 provides the court with discretion to abridge the acceptance period. But wording of that provision makes it clear that the starting point is it won't work. It reads, paragraphs 3 and 4. 3 is the benefits of the defendant making an offer that's not beaten, and subparagraph 4 is for claims. Paragraphs 3 and 4 do not apply to a Part 36 offer, which A has been withdrawn, B has been changed so its terms are less advantageous, and C made less than 21 days before trial, unless the court has abridged the relevant period. So there was no application before trial to abridge the relevant period, and the court held there was no good reason here to abridge it. And it took into account, amongst other things, the fact that the claimants were commercial organisation and legally represented, and the defendant was a litigant in person. So they never got anywhere closer to establishing that they should be able to rely on the Part 36 offer. And as a result, they lost the benefit of that. If they'd made it a day earlier, it would have worked. And just a sideline on this, 2 other cases that came to my attention when looking at this. One is called Reader and SPIE Limited from 2021, where it was held that if a Part 36 offer had been made, and it wasn't made 21 days before trial, if the trial ends up being adjourned, that doesn't change the fact that the offer was still made within 21 days of trial. So in the normal course, it would not bite, even if the trial comes back in 3 months' time, which is clearly a little trap for the unwary. It wasn't something I'd come across before. So mental note to self, if you have that situation and a trial is adjourned off, just make the offer again straight away, because then it will bite. And the second oddity that I came across is a case called Mate v. Mate from 2023, where it was held that a judicial reading day where the parties were not required to attend did not count as the start of the trial for the purposes of calculating the relevant period. So in the case of Henderson and Jones and Price, if the first day had been a reading day, Part 36 offer would have been made in time and would have been effective. Okay, so the second case is also involving Henderson and Jones, and it's the defendant was Salica. Henderson and Jones, I gather from reading these cases, is a litigation funder which buys causes of action from insolvent parties. So in the case of Salica, the decision went in favour of Henderson and Jones on this occasion. This was a high value case involving a breach of confidence claim It went to trial, and the claimant succeeded in getting 2.15 million in damages. There had been various offers exchanged during the course of the litigation, but the key one was one which the claimant had made, which they'd clearly beaten at trial, but they had made reference to the relevant period, but hadn't specified what the relevant period was. So the defendant says, well, it's not a valid Part 36 offer. And they referred to CPR 3651C, which requires a Part 36 offer to specify a period of not less than 21 days. So there's no reference how long the relevant period is. So they say it's not a valid Part 36 offer. But the claimant said, okay, but you've got to look at the whole chain of correspondence and the series of offers. Both on the claimant side and the defendant side, there had been previous offers which specified that the relevant period was a period of 21 days. Plus, the claimant's offer in question had the usual wording to the effect that if you think this offer is not compliant with Part 36, please inform us by return, or words to that effect. I'm never quite clear if those words really make a difference, but they can definitely help in circumstances such as this. Claimants also pointed to the fact that there's provision in CPR 36(8) whereby the offeree, the recipient of the offer, can ask for clarification of the terms of the offer within 7 days. And if they don't get an answer, they can apply for an order that the offeror clarifies. So they ignore the provision for asking for clarification. They don't come back and say, we don't think this offer is compliant. And in light of the course of dealing that there had been, the court held it was still a valid offer. So effectively, they tried to get off in a technicality and it didn't work. The court applied the judgment of C and D from 2011, held that in context, a reasonable solicitor would have understood the offer as referring to the relevant period of 21 days, consistent with the chain of correspondence up to that point. And of course, in a case like that, it makes a massive difference. Claimants beat their own offer, and as a result, they obtained additional interest on the judgment sum, interest on the costs, and an additional amount, 75,000. Quantification of the additional amount under 3617(4), in most cases we come across is an additional 10% of the amount awarded. If you go over 500,000, you get 10% of the first 500,000, and then 5% above that, but there is an overall cap of 75,000. So in this case, because they've beaten their own Part 36 offer, they got an extra 75,000. And just a note on the interest, the court had already ordered interest at 5% above base rate. So when it applied the provisions of beating your own CPR Part 36 offer, it increased it to 10% above base rate, as you might expect. And it followed that when ordering interest on costs. So it awarded 5% over base rate for the interest on costs, matching the uplift it had made on interest on damages. Okay, the third case I wanted to talk about was Cooper and Ludgate House. That's reported earlier this year. And it's a timely reminder that overcomplicating your offers can mean that you actually lose the benefit of the offer itself. This was a dispute between some owners of flats in a block of flats and the developers of an adjoining high-rise building. Mr. Cooper on the one hand and Mr. and Mrs. Powell on the other were the claimants, and they brought proceedings alleging infringement of their right to light. They were seeking an injunction to prevent any further development and to demolish what had been built, and any alternative damages. The defendant, having made some piffling offers at an early stage, closer to trial, made Part 36 offers of £500,000 for each claimant. At trial, claimants were successful. The court refused to grant the injunction, exercising its discretion not to do so, but awarded substantial damages. Mr. Cooper got just under 400,000, and the Powells got 570,000. So the Powells had beaten the Part 36 offer anyway, but Mr. Cooper had got 400,000 instead of the 500,000 on offer. So the defendant said in his case, he'd failed to beat the Part 36 offer. However, they didn't succeed on that argument. Why? Because their offers come with onerous conditions, and in particular, a requirement that the claimants would have to relinquish not only their existing claims, but also any future entitlement to statutory compensation in relation to a neighbouring site where an associated company, the defendant, was also planning to develop. So they were being asked to forfeit their prospective rights that were nothing to do with the existing claim, and that were, if in effect, incapable of being quantified. The court held that the onus was on a defendant to show that a claimant failed to beat its offer. And in order to do that, it had to be able to quantify what its offer was worth, the value effectively that it was being offered. It was argued that the Part 36 offer wasn't valid at all on the basis it included provisions that were nothing to do with the existing dispute. But the court disagreed. It held it was a valid Part 36 offer. That wasn't the difficulty. The difficulty was that the onus was on the defendant, and the defendant couldn't show the value of what it was being, what it had included in its offer. It couldn't show the value of the prospective rights that it was asking the claimant to give up. And therefore, it couldn't show that Mr. Cooper would have been better off accepting the offer. As a result, because it had effectively overquantified, overcomplicated its offer, it was unquantifiable. So it did not get the benefit of beating its, or the claimant's failing to beat its offer. So on the one hand, the court made it clear that it was a valid offer, still a valid Part 36 offer. If it had been accepted, it would have been binding. But the defendant failed to actually get any benefit out of it in the end. Okay, the next case I'm turning to is about the withdrawal of a Part 36 offer. And in a way, this isn't particularly new ground, but it's a recent case which reaffirms, I would say, the fact that it's difficult to withdraw a Part 36 offer unless you can show very good grounds for doing so. This is the case of Chinder and Cardiff and Vale University Health Board. I've been in the process of trying to prepare some notes, and I can get those polished off before the end of the week. and they can be sent around to anyone who wants them for sure. So don't feel you have to kind of make a note of the cases as we go along. I should have said that earlier, shouldn't I? Anyway, in the case of Chinder from 2025, the case involved a serious spinal cord injury which had led to paraplegia, and there was an admission of clinical negligence on the part of the defendant. Causation was complicated but was largely agreed. 3 months before trial, there was a settlement meeting. And at the settlement meeting, the claimant had introduced a claim, which appears to have been for the first time, for provisional damages and alternatively a variable PPO, periodical payments order. Up till then, certainly the defendant had been working on the basis of either a capital sum in total or a capital sum and a fixed PPO. So at the settlement meeting, various offers went to and fro, and we're talking substantial sums. The best offers made by the defendant were to offer 4 million as a capital sum plus specified annual payments, not variable, or alternatively a total lump sum of 7.35 million. Parties didn't reach any agreement at the settlement meeting, but the very next day, claimant made a Part 36 offer that was almost identical to the latest offer that the defendant had made, including a PPO, but was on the basis of provisional damages and a variable PPO. So that was on the 2nd of July. On the 8th of July, claimant solicitors wrote to the defendants saying that the claimant wished to withdraw his Part 36 offer, but that's within the 21 days. On the 22nd of July, so close to the end of the period, the defendant served notice of acceptance of the Part 36 offer. So the question arose, is the claimant stuck with that? The relevant provision is CPR 3610, which applies where the application to withdraw or indeed to change the terms of a Part 36 offer is brought before the end of the relevant period. If the offeree, person receiving the offer, doesn't serve notice of acceptance during the relevant period, then any notice of withdrawal or change will take effect at the end of the relevant period. So here, claimant makes the offer, a week later, less than a week later, they serve notice to withdraw it. If the defendant doesn't accept the offer and the 21 days ticks by, the offer is withdrawn as at the end of the 21 days. But where it's accepted during the 21 days, CPR 3610(3) provides the court may give permission for the original offer to be withdrawn or its terms changed if satisfied that there's been a change in circumstances since the making of the original offer and that it is in the interests of justice to give permission. So the starting point is you can't withdraw it within the 21 days unless you get the court's permission, and in order to get permission you have to show that there's been a change of circumstances and that it's in the interests of justice to give permission for it to be withdrawn. And in this case, the court reviewed the cases, starting with a case called Comper and Apothecary back in 1941. So before Part 36 existed, but in the era of payments into court, where it commented that there's nothing contractual about a payment in, it's a wholly procedural matter, has no true analogy to a settlement arranged between the parties out of court, which of course does constitute a contract, and referred to it as a self-contained procedural code, and that's very much the case. So of course, the rules of offer and acceptance don't apply. Interestingly, sideline, I've dealt with at least 2 cases where one side has made a Part 36 offer, the other side has rejected it in correspondence, but then gone back at a later stage and accepted it. And the fact is, if that offer has not been withdrawn by the party that offered it, you can accept it, even if you previously rejected it. In contract, the rejection would kill the offer. But Part 36 makes it clear that you can accept an offer at any time. Anyway, back to this case of Chinder. The court effectively adopted the dicta from previous case law. The party wanting to withdraw the offer must show that there are good reasons for the application. For instance, the discovery of further evidence which puts a wholly different complexion on the case, or a change in the legal outlook brought about by a new judicial decision. Clearly, neither of those things apply. That's not supposed to be an absolute list, but you can see that the party wishing to withdraw their offer has to show that there is something which puts a wholly different complexion on the case, effectively. In this instance, the claimant was arguing that he'd had further financial advice, that the decisions were very complicated, that he was vulnerable, but overall, the court was not persuaded that any of those things got close to what was required for it to give permission to withdraw the Part 36 offer in the 21 days. And the court emphasised the very strong public interest and the interest of justice in offers being honoured and in the terms of the Part 36 overall structure and being upheld. Okay, and finally, the case of Smithstone and Tranmore Primary School. In this case, that's from 2026, so quite recent, from January in the Court of Appeal. This is a classic example of how tiny cases can make a big difference. The matter in issue there was whether a Part 36 offer, in this case, offering to settle liability on a 90-10 basis in the claimant's favour, was a valid Part 36 offer. In this case, it was a child who'd had a fairly minor injury at school who was suing the school for damages. There had been pre-issue offer made, settle liability on a 90-10 basis, and separately post-issue there had been a without prejudice offer to settle for £3,500. Neither of those were accepted. Case was listed for trial at the doors of the court. It settled for £2,650, so less than what had been offered in the £3,500 offer. As the claimant was a child, it required court approval, and the Deputy District Judge duly approved the settlement. And then the claimant solicitors argued that they should be entitled to the general benefit of 36(7) and not be limited to fixed costs, because they'd beaten the Part 36 offer on liability 90-10. The district judge disagreed and said, actually, that didn't apply. Part 36 regime wasn't engaged. So there was a first appeal to the circuit judge. Circuit judge held that he was bound by the case of Mundy and TUI UK from 2023, in which the court held that a similar offer on 90-10 liability could not, as a matter of principle, be regarded as a valid Part 36 offer. So the first instance appeal didn't get anywhere because the judge was bound by that. So the case went to the Court of Appeal, even though we started off arguing about £2.5 grand. And the Court of Appeal reviewed the case law, pointed out that there's at least 2 cases which hadn't been referred to in the earlier appeal, being Huck and Robson from 2002 and Broadhurst and Tan in 2016. And effectively overruled the case of Mundy and Toohey and said this was a valid Part 36 offer. So this is effectively removing the uncertainty that there had been about whether a Part 36 offer on liability only can be a valid offer. For what it's worth, the appeal then failed because the claimant couldn't say that they had reached an outcome that was at least as advantageous to the claimant as the proposals in their offer. Why? Because there'd been no judgment on liability. There had been a settlement, and it didn't indicate what the position was on liability. The court said if the defendant had admitted liability in full, or if the judge had tried the case and found the defendant liable in full, it would be the case that the claimant had beaten its Part 36 offer. It's unclear what benefit it might have got, to be fair, because it would have beaten its offer on the issue of liability only, not on quantum, because it hadn't beaten any such offer. But in any event, the Court of Appeal held that yes, you can make a valid Part 36 offer on a liability only basis, but in that instance, no, claimant didn't get the benefit of that because it hadn't beaten its offer or couldn't show that it had beaten its offer. So the appeal therefore failed. So yeah, that's my quick canter through 5 fairly recent cases on Part 36, and I hope that's of use.
Thanks, Stuart. I make it 10 minutes left of the slot. I think we finish at past. So there's no further formal part to this afternoon's talk. So obviously, thank you for attending. Feel free to leave at your own leisure. But Stuart and I will be sticking around to answer any questions that anyone might have. So by all means, feel free to chip in as you want to.
You were telling me, Adam, about a recent case you had where a Part 36 offer had been made in non-monetary terms.
Yeah, I think I was explaining it really poorly last night to you, but essentially my chap's owned a parcel of land, and there was an express right of way to it in 2 different directions, and in reliance on that right of way, we were trying to get to this parcel of land. Other side was saying no, absolutely not. And as I say, we basically decided to make an offer that provided for a release and a re-grant. And in doing that, we ultimately beat the offer when we got the form of relief we wanted.